Hello everyone, my name is Helen Davenport. I'm a partner in the commercial litigation team at Gowling WLG, and in particular I lead our cybersecurity and contentious data privacy work. I'm going to be talking to you today about the NIS regulations, as this is an area in which we may see some new laws coming up the track, so an interesting one to watch. Now, before we get into those, what the new laws might look like, let's just have a little bit reminder of what the NIS regulations are. So, of course, these came into force on the 10th of May 2018. They implemented the EU Cybersecurity Directive 2016 prior to, obviously, us Brexiting. The aim of the regulations is to maintain the security of critical national infrastructure, and in particular, the network and information systems that are critical for the provision of the essential UK services and digital services. Now, if you're an organisation caught by the NIS regulations, you'll be familiar with this, but if not, just bear with me for a moment, just while I just run through the scope and the effect. So the organisations in scope of the NIS regulations are businesses providing certain essential services, and they're referred to as operators of essential services, or OESs, and relevant digital service providers, are DSPs. And they are required to register with the relevant competent authorities. They have to meet a baseline level of cybersecurity requirements, and they have to report any incident which has a significant impact on the continuity of the essential services. Now, just to drill down into that a little bit more, so if you're, or how do you know if you're an OES caught within the regulations? Well, so within for the operators of essential services, that covers a number of identified sectors, and those are energy, transport, health, drinking water supply and distribution, and also digital infrastructure. And then those are in turn broken down into subsectors, and then for each of those subsectors there are designated competent authorities and threshold requirements for a business or an organisation to see if it is caught. And I've just drilled down into one particular example to try not to clutter the slide too much. But in the area of drinking water supply and distribution, you can see that there are a number of designated competent authorities for each of the areas of the UK, and the threshold requirement there is for the essential service of the supply of potable water in the United Kingdom. It's where the supply of water is to 200,000 or more people. So that's OESs and how you would know if you were caught. Moving on to relevant digital service providers. Now those to be caught, that's where a provider provides a digital service in the UK, which might be an online marketplace, an online search engine, or a cloud computing service, and there are definitions for those in the regulations. And organisations that are caught where they have a head office for that provider in the UK, or that provider has nominated a representative established in the UK. And then there's a carve out for micro or small enterprises. And the competent authority in the case of digital service providers is the ICO. Now, I said I was going to be talking about some potential new laws, and in particular talking about the sort of UK government's current thinking in this area. So during the last 12 months or so, the UK government has launched two calls for views, one on amending the NIS regulations and another one on supply chain security. More recently, DCMS launched two consultations in January 2022, and those ended in March and April of this year, respectively. And they are principally geared at having a new legal framework to improve cyber resilience. And why is the UK government thinking about that? Principally for three reasons. One is that there's an increasing awareness of cybersecurity, and that was identified in the most recent DCMS cyber breaches survey that came out at the end of March. So an increasing awareness, it's on the agenda, but unfortunately action lags behind that awareness in terms of doing something about cybersecurity. So that's the first reason. The second reason is the National Cybersecurity Centre is seeing an increased number of incidents and is helping organisations manage an increasing number of incidents, both in the UK, and we're also seeing obviously incidents worldwide as well, and increasingly high profile incidents. And thirdly, there's a recognition of supply chain risk, and there's actually an increased reliance on centralized IT services. And the concern there is that a small number of organizations in the supply chain are actually carrying a high risk in comparison, the potential impact on a huge number of organizations that they service. So this is all in line with the government cybersecurity strategy for 2022-2030 as well. So drilling down a bit more into those consultations. So there were 2 consultations covering 3 pillars. In pillar 1 of consultation 1, so that the focus there was about amending the NIS regulations, and 2 key changes. The first one, to bring managed service providers into the scope of the NIS regulations. And the second one is that digital service providers who have the most privileged access or provide critical services to organizations, they would have a risk-based enforcement regulatory regime, so that actually those that are in the category that I've just described would have proactive supervision from the ICO and reactive supervision from the others. In pillar 2 of the second consultation, so the focus here is around future-proofing the NIS regulations. 3 key changes here. The first one, to actually give the government the power to make quicker changes to the regulations going forward so that they can respond to threats more quickly. The second one, to change the reporting threshold. So at the moment it's just incidents that will have an impact on service, but the proposal there is to increase the incidents that would need to be reported. And thirdly, the introduction or an expansion of the cost recovery regime, so that actually the organisations within the scope of the NIS regulations would bear the cost of the competent authorities regulating them. In the third pillar, consultation 2, that's focused on boosting the cyber security profession, so increased standards. So if organisations obviously need to draw on the expertise of cybersecurity professionals, there's a regime there that makes it easier to see who has the requisite expertise. In the next part of this session, I'm just going to focus on the managed service providers change. So that's within the first consultation, given the potential significance this has on supply chain cyber resilience. So who might be caught by being a managed service provider? Well, the consultation currently proposes that an organisation would qualify as a managed service provider if the services it provides are supplied to external clients by the supplier. They involve regular and ongoing service management of data, IT infrastructure, IT networks and/or IT systems. They're categorized as B2B rather than B2C services, and the provision of the services relies on network and information systems. The consultation also includes in one of its annexes a list of potential organisations that the UK government would envisage that this would cover. Now, 2 points of note. The first, that it's broad, and the second is that it's a non-exhaustive list. So here on the slide I've got the headline categories, but if you're looking at the slide, you can also see that there's more detail within them. But in headline terms, the categories are managed network support services, security services, outsourcing, analytics and artificial intelligence, workplace services, business continuity and disaster recovery services, consulting, and lastly, software engineering service, such as where the managed service provider develops the source code, maintains the source code, or stores the source code in its own repository. So broad, and the government is also consulting at the moment whether actually there would be an additional threshold to be a managed service provider. So it's also under consideration whether to be regulated, a provider would also have to have privileged access or connectivity to a customer's data, IT infrastructure, IT networks and or IT systems, or they would have to perform essential or sensitive functions such as the processing and or storage of confidential or business critical data. There's an understanding in considering whether to introduce this additional threshold in that narrowing, so having this additional threshold may be helpful, but could that leave risks to supply chains where actually there's an organization who are providing services or can have an impact on that supply chain if they would fall outside of this threshold. But on the other hand, having too many organizations, so but if we don't have a further threshold, that might mean that you've got organizations in scope who it will not be appropriate for them to be in scope for the organization or business having to bear additional costs, and also for the regulator will incur additional costs if it has to regulate too many organizations. So then there needs to be a purpose for them doing so. So that's one to watch in terms of following the consultation where actually this definition and or any additional thresholds might land. But for those businesses who are managed services providers in the future, well then the proposed requirements that they will have will mean that they have to register with the ICO as the competent authority. They will have to make sure they have in place adequate and proportionate security measures to ensure that their own network and information systems are secure. They will also be required to report relevant incidents to the competent authority. So if not already in place, then organisations may prepare their business or need to prepare their business to undertake rigorous independent audits and to ensure compliance with the security expectations of the ICO. In terms of what those expectations might be, at the moment, well, there is no guidance at the moment, and that's expected to be determined through guidance in the future. So something else to watch out for. There's also, as I mentioned earlier, those digital service providers who have the most privileged access, providing the most critical services, will then have proactive supervision from the ICO as well. Those managed service providers will also have a cost impact in terms of getting to grips with the regulations, that initial administration costs. There may be the additional increases in cybersecurity spending to make sure the security measures are met. And if an incident does arise, then there will be cost consequences in terms of having to deal and report that incident. And further, as I also mentioned earlier, there's an expansion or proposed expansion of the cost recovery scheme, so the managed service providers would also have to pay their part towards the regulators' costs. So that's what's proposed at the moment, what's under the consultation. Very much one to watch when we get the results of the consultation. If you're a customer of IT services, then this will be of interest to you because your providers in your supply chain may be the subject of increased regulation, which may have benefits for you. And if you're on the other side of the fence, if you're a supplier, then of course you will be concerned to understand whether you're inside or outside this definition of managed service providers and whether you will have the additional regulatory requirements that I've just talked through. Thank you very much.